Well, Ms. Nelson says that he filed a conflict about me to be in Henry County, but that was this morning. I don't know when he filed it. He was supposed to be in Henry County this morning. It doesn't sound like he sent us a copy of that conflict, because then we would have known about it and not had to poke around a little bit. While Ms. Nelson is doing her recon, why don't we handle Mr. Alexander? Sorry. But one guy is resolving his revocation, and then I will not keep you here longer than necessary. If we learn that Mr. Green's defense attorney's just not going to be able to show this afternoon, we'll get you out of here. But I know you're both from Clayton. Came all the way from Clayton. Sorry about that.
I spoke with Mr. Melnick yesterday, so I was expecting
him. And he didn't say, "Oh, by the way, I'm in Henry County." Okay, and it could be he's en route, trying to find a parking spot. Ms. Nelson will press all the right buttons.
Oh, there he is.
And there he is. Woohoo! All right, you can set aside the bench warrant, Ms. Nelson. Thank you.
Judge, I don't know if you're just waiting for my announcement. I got information from Mr. Lagarde yesterday evening. That I kind of need to go over with my client.
Okay. I don't, in fact, because we were tracking down your whereabouts. I know you had been in Henry County. I asked that the other defendant who's on for this afternoon be brought out. His is not a contested revocation, so we're going to do the revocation hearing. It's effectively a sentencing. You can use that time to speak with Mr. Green. We do have two officers from Clayton County here, so we'll want to be mindful of their time, but you should take your time to talk to Mr. Green. And if we need to go forward with the evidence, we can certainly do that.
Thank you.
All right, let's pivot then. And all right, Ms. Fowler, good afternoon. Can you hear me? Oh, Ms. Fowler?
Judge, she's requesting that the mics be turned on. I'm not sure if they're on at the defense table or whatnot, but she can't hear.
Okay, well, so far, some of the people who were talking weren't near any microphone at all. I just want to make sure she can hear us. Your green light is on. Yeah? Okay, and your green light is on, Ms. Dilligard?
She said she can hear everyone, but you cannot hear her.
Okay, that is correct. We cannot hear her. But as long as she's good to go, then we will proceed. So let's get on the record in the state versus Stevenson Alexander. I have three cases: 22 SC 182 429, 22 SC 183 196, and 22 SC 184 175. They're all shoplifting cases, and in each of them, there is more than 5 years. There are more than 5 years remaining on probation. I signed warrants in each of those three cases in January of this year. The allegation in the warrant is that Mr. Alexander in November of last year was arrested by the Atlanta police for a new shoplifting charge. And there's an additional violation alleged that Mr. Alexander did not enroll in and successfully complete sober living. We were together a few weeks ago, it may have been a month ago, at which time Mr. Alexander told me that he wanted an evidentiary hearing, in other words, for the state to prove up the arrest for shoplifting in November of last year. So we reset this so that Ms. Dilligard could get the right witness or witnesses here. But a few days ago, Ms. Rios sent an email out saying, we're withdrawing the demand for an evidentiary hearing and we'll focus on sentencing here is the wrong term to use, but sorting out what are the consequences for these two violations of probation. Is that still the situation, Ms. Rios?
Yes, Your Honor. So when I went at court, when I talked to him, I think it was a little confusing. He said he didn't want an evidentiary hearing and he was just wanting to find a program.
Mhm.
And so that's what we've been working on the last few weeks, is getting him finding out the options he had for programs.
Got it. Okay. Don't worry, Mr. Alexander, you're gonna time to talk. So what you've been working on, you and Ms. Ross and others may have been working to find program or programs for Mr. Alexander.
Yes, sir.
Okay. Are you prepared to go forward with whatever those recommendations are?
Yes, sir.
All right, Ms. Dilligard, are you ready to go?
Yes, Judge.
Mr. Alexander, tell me, you are giving me that look I'm familiar with, which is, I don't like what's going on here. I know you're not confused in the sense that, but tell me what you're confused about. We've been around and around. You are a sophisticated individual. I've worked with you in drug court. I've worked with you outside of drug court. What's the confusion?
I'm getting something else being told about about this evidentiary hearing. I never, like, to my understanding, when I last spoke with her, she telling me about this evidentiary hearing is about something that I'm on probation for, shoplifting for. It's something about trying to get some cases for my charge that I'm on probation for. That's the understanding what I took. I did not know the evidentiary hearing is about the new shoplifting charge that I caught from last year about trying to clear that up.
So I've probably said something that was confusing, and I'll own that. Let me tell you what this is not about. This is not about you pleading guilty to the new charges or anything like that. But if we go forward with an evidentiary hearing, what probation has said to me is, hey, Mr. Alexander's not doing so well on probation. And there are two reasons why he's not doing well. One, he shoplifted again, and he's on probation for shoplifting. So we think there should be a consequence for that. Number two, he didn't complete sober living. Put that one to the side. Let's focus on the shoplifting. Unless you stipulate or admit, hey, I got arrested for shoplifting again, the only way that I can decide there should be consequences for what happened in November of last year is for the state to call a witness. Maybe it's a loss prevention officer. Maybe it's an Atlanta police officer to say, I'm doing my work. There's this guy. He runs out of the store. He's got a bag full of stuff. He didn't pay for it. And it's on video and it's you. I'm making it up. But let's say what the evidence is. I would be finding then not, you're going to jail for the new charges. I don't know where those new charges are. They haven't been indicted yet, probably. I'd be deciding, here is the consequence for your probation, because while you were on probation, I've concluded that you did another shoplifting. That's what the evidentiary hearing would be about, is for the state to persuade me, if they can, that in fact, while you were on probation in November of last year, you did another shoplifting. And if I agree with the state, you're not guilty of the new case. We're just dealing with, well, what's the consequence for what you're doing on probation? Does that clear it up? Because if it doesn't, keep asking questions.
No, it clears it up.
Okay.
I have no problem with that. All right, I have no problem with that. My argument about that new charge, that's between me and that new charge, and it ain't got nothing to do with probation. I understand that part. Okay, now, like I said, you're innocent for purpose guilt. That's something I gotta do with probation. I go to court on the 29th for that. But I got this charge because they did something they did a real misconduct on my charge, which it's supposed to be dismissed, and I want to fight it all the way to the trial. But now, since clearly you're telling me that it's a violation by me getting arrested for that charge, I'm gonna have to live with that. But that's another issue. The other issue is about this about this, which my lord is trying to explain about the sober living part.
And I'll hear her about that. And you told me a little bit about it last time.
Yeah, cause I tried to enroll in there, but now she got people that try to enroll inside there, so I'm trying to leave it from here.
Okay, so you feel like things are cleared up a little bit. All right. Ms. Rios, why don't you get us started then?
Yes, Your Honor. Mr. Alvin has had a, long history with the youth, and I'm sure you're aware of what the drug court. We did try to do drug court again. They denied him when we did an application to drug court. But sober living said that they would allow him to come back. And to me, I don't know exactly what happened when he tried to go, but the fact that they're saying that he could come back, says to me that maybe it wasn't all on him. I'm not sure. We don't know exactly what happened. And so, but they're saying that they would take him back if it's court ordered. They said he's done the intake process. Ms. Ross was on the phone when they did the intake process. And that's where he would like to go and try to see if that helps with all his history, these new cases. I know he's saying that he's trying to fight the new shoplifting, but that all stemmed from his abuse, his drug abuse issue. He's not a violent felony. I don't believe he is a danger to society as a whole. And so I'm asking that you revoke the time that he's been in and allow him to go to the sober living program.
Okay. Do you have a PI number or anything for that? I have a booking number, but
I have an SC number.
You have an S, it's been indicted?
Yeah. It's
after me saying it hasn't been indicted?
It's in non-complex right now.
For now?
Yeah.
Okay.
24 SC 006463.
Yeah.
Okay, you do have a hearing on the 29th. You're right. I don't think it's one where people are going to be throwing the case out, but it was dismissed originally. It meaning that charge in December, it was dismissed. This would explain why you have a new booking number, because the officer didn't show up. Not because it's a good case or a bad case, and I'm not telling you it's a good case or a bad case, but if an officer doesn't show up for a preliminary hearing twice, then that second no-show, the judge says, we're throwing the charges out. And so if you were still in custody, you would have been released if this was the only thing holding you. The DA's office is still free to bring those charges because the judge didn't say they're bad charges or there's no evidence. They said, we don't have an officer here to establish probable cause. That's what happened in your situation. It sometimes gives a defendant a false sense of hope that, see, my case is no good. The judge threw it out. The judge didn't say anything at all about good case or bad case. She basically said bad officer because the officer didn't show up. So I'm going to take a quick look at.
I have a valid argument.
I bet you do, but this isn't the place where we need to go into that. Okay. Ms. Dilligard, what is your recommendation for Mr. Alexander?
So my notes indicate that this would be his second revocation. He had a revocation back in October of 2023 for a new offense and also some technical violations. He was revoked 7 months then. And that was just a few months after pleading guilty on this case.
You said in October of 23?
Yes.
Okay, I see it.
And I also see that he has at least 5 theft by shoplifting convictions. After conversing with probation, I believe probation's recommendation was to revoke 3 years. I'm asking for a minimum of 2 years to be revoked from his sentence.
Okay.
I have a question, sir.
I'll get to you in a sec.
I believe his original sentence was 8 to serve 1 on the 4175. Is that what it's?
Okay. So the order that I entered that revoked the 7 months said, here are the findings. He didn't report, he didn't complete sober living, and he had a new shoplifting. So all those things you said. Interestingly, the special conditions, I modified the special conditions. One, it set a behavioral incentive date. That didn't go well. But two, it said Sober Living America no longer needs to be completed. So I'm wondering if half of this particular warrant we ought to set to the side. And I'm going to ask Ms. Simpson with DCS to let me know if, since this order was entered in October of 23, was there something that happened after October of 23 where sober living was reinstated as a condition, or maybe just someone didn't connect the dots?
I believe this officer hadn't realized that you had removed that part of the special condition.
Okay. All right. Got it. Anything else? Well, let me start with Mr. Alexander since he's raising his hand. Yes, sir.
Yes, all right, back to what you were saying, what you violated before, for the first violation, because, to my understanding, I feel like I got revocated because I didn't report. Now, the new charge, what new charge did I didn't catch no new charge on that. And I thought, I thought I made it clear from the first time you revocated me and sent me down there for 7 months, straight day for day. I'm thinking that I'm gonna be in jail, doing half that time and get released from jail. You gave me 7 months, day for day.
I did.
Yes.
Yeah, I agree. That's exactly what it says.
Because I'm like, okay, for not reporting, I didn't catch no dirty urine. I didn't catch no open charge.
Right. So we're going to disagree on that one. What I put in my order and what I had evidence in front of me was, 1, you didn't report.
Okay.
2, you didn't complete sober living. 3, the big one, you had another shoplifting, May of 23.
Other shoplifting.
Okay.
That was the thing.
Well,
That was the thing.
We don't need to litigate that now. You did your 7 months. That's water under the bridge.
For nothing. I mean, for false accusation. I'm a victim of false accusation. That's what I'm saying.
Okay.
Okay, because you sent me down there and then I'm trying to get my head straight. Like, why am I going back to prison when I say didn't do nothing wrong? And then I'm only 2 months out of jail. 2 months out of jail. I only missed 1 time, and you revocated me. And then I'm trying to get that clear. I mean, out the way. I mean, like, that understanding I did is like, I was confused. Why am I going back to prison for not reporting? Okay, that extra shoplifting charge, listen, I did not catch no extra shoplifting charge. I did not catch no I had no open charges. I had no open charges. And then I clearly explained that to you for the first time when I first got revocated. I thought I cleared that. But you told me out your mouth saying that, well, the reason why I'm revocating you because you could have showed up to your probation officer. You could have went to the probation office because my job was to stay at home and wait for the probation to come see me. That's that.
We gotta talk about the correct thing.
No, this has to be in it because you bring it up. I have to bring it up because now I'm clearly saying that I've been falsely accused false application. Yeah, it was false accusation. I mean, it ain't no due process right there though. It ain't.
Okay, you keep going. I'm listening. I'm looking up your arrest, and I'm happy to talk.
Because I got done wrong. I ain't had a dirty urine. I had an open charge. I know I had an open charge. Go fast. My family can vouch for that, and they're not here right now. That's the reason why I kind of got upset out there because I'm not prepared.
Got it. So here's what we got. You were arrested in May of 23. There's your booking picture, tattoo on chest. Gladys Alexander's your emergency contact. And you were arrested. You have a failure to appear at a East Point and.
Yeah, East Point, yeah.
Yeah.
That charge was 2 years old. That is not no new charge. That's not no new charge. That's what I was trying to explain.
You're right. It's what you were arrested for was this failure to appear. You were arrested on May 20th on that warrant. And let's see what else is in the system about that.
That was a 2-year-old charge, way prior before I got sent to this probation. It was way before that. That's like a double jeopardy type thing to me. That what it sounds like right there.
Then in 2024, the district attorney's office declined to prosecute you for the charges that were connected with that arrest. So you that may be something you want to explore later on as to what the arrest was for and how it shows up as shoplifting. Because if you look at what you were booked in for, it was this failure to appear. So it says theft by shoplifting here. Maybe it was a failure to appear for a real old shoplifting case. And yet it showed up in the system as here we are in May of 23 and you're getting arrested for a new shoplifting case, but it was actually an old shoplifting case. Got it. Okay. Well, you can be sentenced to less than 2 years for technical violations like absconding and not completing sober living. So that sentence you did get, that revocation, back the 7 months was for not completing sober living, not reporting to probation, and supposedly the new shoplifting, which you're helping me understand, was actually a real old shoplifting, and what you got arrested for was a failure to appear. The 7-month revocation is still a legal sentence for just the two of not appearing and meaning not reporting to probation and not completing sober living. But you know what, Mr. Alexander, I'm going to cut you off.
The sober living, I told you that when I went to sober living, I told you I had to pay a little I owe rent over there. I couldn't be admitted inside sober living. I went home that same day. I went to the probation officer that next day and explained what had happened. The understanding was for me to stay at my mother's house.
Okay.
That's it.
Well, that revocation has already happened. We're here on a new one, and the basis for the new one is a new shoplifting, not a failure to appear. It's a new shoplifting. You got arrested with a bag full of meat, hadn't paid for it. You're going to fight that in non-complex, although it will likely move out of non-complex.
So I'm just going to be done wrong again. So it's like I'm just going to get revocated again.
What part's
I'm gonna be the first time I got revocated for, I got railroaded.
okay?
Plain and simple. Plain and simple. It wasn't fair. It wasn't no fair hearing.
What part's not fair this time?
Huh?
What part's not fair this time?
I'm not talking about this time. I'm talking about the first time.
Okay, I'm talking about this time. Now we're good.
Right now, it is what it is right now, because see, right now, I'm supposed to be going back to a sober living program and get my life straight. And then clearly, man, you see I'm an addict. You see I'm an addict.
I
need help.
you do need help.
I need that help.
And we have tried hard. Drug court was your big opportunity, but that one didn't work out so well. Mr. Alexander, in light of your recent arrest for shoplifting.
One moment, sorry, I just wanted to add one more thing if I could.
Really?
Yeah.
Okay.
Sorry about that. There is an additional arrest from February 27th of this year that is on the petition that Ms. Simpson just provided me in counsel that he signed back in March.
Okay, and what was that arrest for?
Possession of MDMA.
Okay. And that's the booking number we're dealing with now. There is a 25 booking
Yes.
number, so it's not a booking number in connection with the shoplifting. I thought it was a booking number in connection with the probation warrant, but it's actually, it's also connected to new charges.
Or meth.
Is it on this one?
Is it on
This one just says stop.
Well, I don't need to get there. There may be a new case for Mr. Alexander to work through at a later date in connection with those new charges. But I want the record to be very clear that based on, it's just one violation remaining in the warrant that I signed. One of them was not completing sober living. That wasn't a condition anymore. But Mr. Alexander was arrested yet again for shoplifting in November of last year. It's an indicted case. It's moving its way through non-complex. It will likely get bumped to a Superior Court judge. In the meantime, I'm going to revoke 2.5 years, 2 years, 6 months of Mr. Alexander's probation in each of the 3 22 SC cases. I will reinstate the balance, and I will add as a special condition, so it's back at Mr. Alexander's request, a directive that Mr. Alexander enter into and complete the sober living program, because he has told me about 5 times today on the record that he needs sober living and he wants to do sober living, so he'll have another chance to do that. Thank you.
So, to my understanding, you're going 2.5 right now?
That is a correct understanding.
I guess, Judge, we're just, trying to, will the Met case come back? And you have to have another revocation on that one?
So,
I didn't find out about this till today.
right, and so you weren't expected to be ready for it. We weren't gonna postpone what we were doing today. And I made clear on the record that today's revocation of 2 years and 6 months is predicated exclusively on the shoplifting arrest from November. Not a sober living issue, because that actually was not a condition anymore, and not because of the MDMA. If you are able to have a fruitful conversation with him and want to roll that into the 2.5 years, I'm happy to do that. But I wasn't about to get into that space. We would have been here another 2 hours. So he's not being found liable for that, but it's also not, he's not cleared of that from a revocation perspective, if that makes sense. Your question was a smart one. We weren't going to try to navigate that today.
If he goes down the road, would he be able to?
He will.
Okay. Would he be able to come back and we handle this once maybe he's calmed down?
Mm-hmm. We could get him on Zoom from GDC and say, hey, we're going to do another revocation based on, once everyone has digested this just in, and I understand it sounds like the petition was actually from March, but whatever, I think you said it was a while ago. I hadn't seen it either. And this wasn't the time or place to work through that. But it would be better for him to get that piece cleared up as well, because technically he's still on the hook for a potential revocation in connection with the February 25 arrest. And we could roll it all into this if you can connect with him. All right. Thank you for your work with him. Had Mr. Melnick talked with Mr. Green yet, or he wasn't able to go back there while we were doing our thing?
He just told me that he thinks he's gonna stipulate, but I don't know if he had talked with him yet, and he was
Okay.
just asking me about custody dates, so.
Okay. Assuming that's Mr. Alexander. He had a lot to say.
Before too. He came out.
But I understand his frustration about that, the last revocation. It's a real weird, if you look at the CP number associated with that May arrest and the ticket, he gets arrested, but it looks like it was a failure to appear on a real old shoplifting way before 23. But the way it got put in the system was as if it were a new shoplifting. That's what his booking screen says. So if I'm probation, arrested for shoplifting, and take out a warrant. It's what it looked like on the surface. I don't remember the revocation hearing in October of 23, and I wouldn't have been with you. I'm sure there was lots of squawking, but poor Mr. Alexander, there's always an issue with what's going on. And so he loses a little bit of credibility and we said, wait, no, something unfair is happening. It sounds like that may have been not quite right. But it was not a revocation that exceeds what you can revoke for technical violations. Was Mr. Gibson your case?
Yes,
He's gonna be here tomorrow morning?
should be,
Okay.
we've been in touch.
You doing all right, all things considered?
I sell all his furniture.
Really? I guess that's sort of what you have to do.
Well, when I need it, hope so first.
Oh.
I was like, go on Facebook Marketplace.
Full service public defender.
Who's better?
Didn't he say he had other overseas somewhere?
Oh, yeah. I
Right,
think he did.
good
Yeah,
memory.
I believe he did. Yeah. I think he did. Because I think that's who he called me on freeway with, like, we've been talking, so I'm gonna call him to make sure he'll be there tomorrow.
Judge, there's some things about it. We were I remember maybe Thursday. While we were in court.
Really?
Yeah.
About what?
Some things in regard to more so part of what we discussed. In regards to.
Right, and warrants and what we're gonna do.
Yeah, and that part of it. But I need to get some more clarifications in regards. I think there was some things that. I think it's a program. Like, for new police that are going to stuff. Our recording days can only be things. And then.
Wait, you're what?
Our recording days can only be one Wednesdays.
Who's saying that? DCS says that, or
That is what was told to me when I asked for an update from the meeting.
who makes that decision? That's odd.
From my understanding, that's part of what needs to be clarified.
Okay.
Because they're trying to make sure that's actually correct. And then as well as, in regards to how to handle and maintain this probation between us, the probation and drug court.
Right.
So that they're, apparently some this being this.
Okay. I'm gonna send an email to Judge Kraus saying, was there a meeting I didn't get to, and what were the results? Because if she says now they can only report on Wednesdays, I can say, well, why was that?
Because, yeah, I wish they would have rescheduled that. But they could.
Yeah.
Actually, yeah, my hand comes to good thinking that just crossing out the same page with you. Great.
Yeah, well, we may not be, I don't know what page to be on. I may think they're great ideas. I can't tell.
All right, see y'all tomorrow.
All right, thanks for dropping by.
this afternoon.
All right, Mr. Melnick, we've got two officers who are ready to testify or ready to leave.
I
What's
see
the
that.
plan with Mr. Green? You want to get Mr. Alexander downstairs? He seems frustrated. You got this? Okay, he's in a safe space right now? Okay.
Going there yourself.
There is a firearm in the car,
Okay.
but there's also a firearm in his job.
Okay. In the search, canine units on the braid. Shoe. Oh, okay. But so that was still in the car.
All right, I sent Judge Krause an email. We'll see
The
what happens.
bag that was on his person.
Yeah.
And
Oh, okay. I get it now. I got it. When they were tracking it down.
right.
Okay.
I mean, he made you do something different than the past.
I know.
Should we bring Mr. Green out? Let's bring Mr. Green out.
Because the department was at 5 years. She went over the load and chair. Judge, we have a stipulation with regard to the violation and with regard to disposition.
Okay, let's get all that on the record and see where we go with that. So we are shifting to our first four positions on the revocation calendar, all of which belong to Mr. Green, who is in court. Good afternoon, sir, with his lawyer, Mr. Melnick. Ms. Simpson, you may have shared before, but I don't have it in front of me, the amount of time remaining for Mr. Green on his different cases.
The balance for all 4 cases are 5 years, 4 months.
So he has the identical clock running on all 4 cases, 5 years, 4 months. All right, so Mr. Green, you've got a little under 5.5 years remaining on your probation across these 4 cases. Some pretty serious charges and some less serious charges, all pretty old. I inherited those cases. Judge Downs was the judge who sentenced you to whatever you got. She has since retired. Her docket went to another judge, and me. And in January of this year, probation came before me to say, Mr. Green's gotten in trouble again. Specifically, in November of last year, you were arrested in Clayton County by one or more of the officers here for possession of methamphetamine with intent to distribute, cocaine with intent to distribute, a gun, it's a problem, and maybe obstruction, and then more drugs. Oh, a whole bunch of charges. They can't even list them all. There's so many. It says 15 total charges. You were arrested for those things in Clayton County. Getting arrested is evidence of a violation of the law that gets you sideways with probation, and so we are together. And it sounds like Mr. Melnick, Mr. Green is stipulating to his arrests. So yes, these things happened, meaning the arrest occurred, and that's a violation of his probation. You and Ms. Dilligard have been going back and forth about what the consequences should be. Before we get into that, what is the status of the Clayton charges?
Unindicted.
Unindicted. Pending, is Mr. Green out on bond from those?
He has a bond, but he has not posted that bond, Judge, so he's been in continuous custody since November 19th of last year.
Okay, and this warrant got put on him. He came here. Why post the bond? You can't go anywhere anyway.
He's here on a production order from Clayton County.
Okay, got it. And what is it that you are recommending I do in light of those stipulations, Mr. Melnick?
Your Honor, based on the stipulation, Ms. Dilligard and I have agreed that it would be appropriate to revoke 2 years of his probation, giving him credit for the time that he has served since November the 19th of last year.
Okay. So, Ms. Dilligard, if I sentence Mr. Green to a revocation of more than 6 months, credit for time served isn't given. And so if I am to agree that a 2-year stint in custody makes sense, I'll do the math, but it would be more like 1 year and 6 months that I revoke from today, because 6 months of that 2 years has already ticked by, 6 months-ish. So I just want you to understand, I don't know how you need to report it or what you were envisioning, but if I revoke 2 years, if that's what my revocation order says, and I write credit for time served, Department of Corrections will cross out credit for time served, and Mr. Green will do 2 years from today. Now, it's parolable, he might get out in less than 2 years, but his max out date would be May 7th of 2027. And I don't have an issue with that. But I just want you to know that if I go along with what's recommended, then what I'll be revoking is 1.5 years, not because I think 2 years overshoots it, but because what you're saying by saying credit for time served is that you think 2 years of time from the day of his arrest is the appropriate revocation.
Yes, Judge, and I was able to confirm, he showed me his incarceration date from Clayton County. And so I think the original recommendation from probation was to revoke 5 years. I told Mr. Melnick that I wouldn't do no less than 2 years.
Okay. Was 5 years the original recommendation? Yes. Tell me, Ms. Dilligard, other than not putting the officers through the ringer of having to testify, why do you think that 2 years, given the number and seriousness of the offenses for which Mr. Green was on probation, why you think 2 years it's not unreasonable, but why is 2 years more reasonable than 5 or 4 or 3?
Judge, I based that off of his previous revocation back in 2023, similar firearm drug arrest. He was revoked 210 days, and I felt as though that didn't teach him a lesson, so I thought that to double that may do the job. And so that's kind of where the 2 came from.
Okay, that's an interesting nugget. So in 2023, I guess I can look one of these cases up. Let's look up the most recent one, 10 SC. I'm not quite sure why these cases are with me. Maybe the oldest one is Judge Downs because the position 4 was a Ellerby case, which means it's a Schwal case now.
The other 2 were Judge Schwal, and I don't know how.
Okay.
We were dealing with the last revocation. I'm sorry, I did not mean to interrupt. Basically, for the sake of efficiency, everything got combined into your program.
It makes sense. I'm not worried about Judge Schwal coming after me saying, how dare you handle my revocation? It just threw me off because it said an Ellerby case.
Well, funny enough, originally they were on Judge Schwal's calendar, or the positions 3 and 4 were on his calendar to handle, and then we ended up with.
Well, if Mr. Melnick had been retained by Mr. Green, he's going to do exactly what he did, which is try to get them all in one place. And they ought to go to the oldest case, which would be the 08, which is Judge Downs, which is now me. So we're in the right place. So in September of 23, so we met before, revoked you for 210 days for similar sounding stuff. What happened with that case?
It's still unresolved, Judge.
Is that also a Clayton County case?
No, it's pending in the non-complex division.
It's been indicted.
It has been indicted, yes.
Huh. Okay. So while on probation for these 4 cases, you picked up a set of charges kind of similar to the Clayton case. It's been indicted, it's pending, and you got revoked for 210 days. And I guess bonded out, and then we have this situation. Was there anything about your work with the officers involved that made you think, we need to work this out rather than have an evidentiary hearing?
No, Judge. My understanding after speaking with the officers and reading the reports, this defendant fled the scene, but the officers did extensive work to identify him using all kinds of investigative tools. And so I felt strongly about the case, to answer your question.
Okay, got it.
Well, I will add that the drugs in the car, to counsel's point, there was an equal access argument for that. However, the firearm that was that he's charged with was on his person when he fled. So.
Okay, so there was more than one person in the car.
Yes.
I'm not going to dive into the facts he stipulated, but at least it's a group situation in the car. But then either the officers see him discard a firearm, or when they get to him, he has a firearm.
Yeah, they see him discard it. They
Okay.
recover it.
All right. Mr. Green, anything you want to add? How old are you? 37. Okay. Well, Mr. Green, you're going to need to figure out, it's not an easy thing to do. I think you've got family here on your behalf, how to chart a different course, because you keep getting mixed up in whether it's your idea or you're just riding with people whose idea it is. But drugs and guns and you getting together in the same space, it's just going to leave a bigger and bigger mark.
It's my fault around with the wrong person.
Okay, I hear you, and I'm not, you as a person, we all have our own issues and you're working through stuff, but you are now wise enough in the ways of the world that my guess is you weren't surprised that there were drugs in the car. I don't know how surprised you could be with the gun you had on you, but I am confident you knew that wasn't the right place to be. Circumstances are such that you were there. It's not a blame game here. Life is complicated. That may have been, I can make money doing this and I got people I need to support, etc. One way you can't support them is by getting locked up again and again. And these are going to leave bigger marks each time. I don't know what Clayton's going to do. They tend to play less gently than we do. And these charges are pending down there. I'm going to revoke 3 years of your probation and then reinstate the balance on 2 of the cases and terminate your probation on 2 of the cases. I am terminating your probation on the 08 SC case and the 09 SC case, but I'll leave the probation running on the 210 SC cases. Clayton may choose to wrap things up down there. In light of this, I suspect if Mr. Melnick can get people's attention in non-complex, they certainly would resolve your Fulton case in light of this revocation, which is often how these things are supposed to work. But my message to you is at age 40, which is the oldest you'll be when you get out, you'll likely get out before then, just figure out a different way to roll because you'll be in front of a different judge next time. And that judge might say, I don't understand why it should be a day less than 5 years and 4 months. You won't have that much time left, but you've got these other cases to work through. So I hope it turns out differently for you in the future.
Judge, may I be heard quickly?
You may.
So, Your Honor, what happened with this incident that led to his arrest in Clayton County? He wasn't the driver, he was a passenger in the vehicle. And the allegation is that he ran from the scene and that the firearm was found in the trail where they tracked after him. And all the drugs were found in the car, not in Mr. Green's possession. I mean, I did come to him today with the agreement of 2 years, and that was what he was expecting. Do you mind if I talk to him real quick, since that's not what he's getting here right now?
Sure, you can certainly talk to him. A few things. One, this isn't a final plea type situation. 2, I appreciate your recitation of the facts, and I'm fine because we've got the officers right here to do the hearing. And if we do the hearing and it sounds less good for Mr. Green than what you described, then we have the original recommendation from probation that's on the table. And 3, just make sure you also explain that this remains fully parolable, et cetera. Okay?
All right, Judge, thank you.
That was the conversation?
Yeah.
All right, good conversation. Mr. Green, I hope when we meet each other again, it's in better circumstances. And don't handle it like Mr. Alexander is handling it.
All right, I'm good.
I appreciate both of you being here. It was necessary. It got resolved without you testifying. You may need a subpoena signed or something by Ms. Dilligard, but we always appreciate folks coming from other jurisdictions. Not always easy to pull off. What does CAGE stand for?
Criminal apprehension and gang enforcement.
Ooh, that's like, what's it called? Vicar? They don't call it Red Dog anymore because cops went to jail for Red Dog. But APD has an equivalent, but it's not CAGE. I like that. Yeah. Yeah. You guys should copyright that so they don't steal it. Thank you for your time.
People going crazy about this.
The crazy part is his answer